public will be able to speak during the public comment period. The public period will be allowed to comment after the consent agenda items and during item number shown in the agenda at the end of the meeting. I move that each member of the public will have 3 minutes to speak. All those in favor?
Aye.
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 Any opposed?
Aye.
Hearing no opposition, the motion passes. At this point, I'm going to turn the agenda over to Catherine Herman, our staff.
Yes. Hi, everyone. And before we get started with the rest of the meeting, I wanted to point out that I saw Doug Klein jump onto the call. So Doug, it looks like you're unmuted. If you would just confirm for us that you are present on the call, that would help us.
I am on the call.
Great. Thanks, Doug. Appreciate that. And then just as a reminder, as we move forward with the slides, if folks could mute themselves, that would just maybe help with the background noise. And, feel free to try to use the chat if you run into any issues, but really we're trying to keep the discussion piece out of the chat. But if you need technical help and you can't interrupt me or something, just go ahead and put it in the chat. So moving right along, I'm so glad we have everyone here today. Just to let everybody know that we did receive a resignation for Leslie Jacobs in mid-June. He was appointed by Supervisor Stork, and so we have let his office know that Leslie Jacobs did resign. So when we have a new member, we'll let you know. But I just wanted you all to be aware of this. So just a bit of a housekeeping thing. Okay, so I had emailed you all kind of a little abruptly about a new policy that the Board of Supervisors and the Office of the County Attorney is recommending that all boards, commissions, and authorities take action on. I included this policy in an email to you all on July 2nd, and I have 3 brief slides on the policy, and then I'm going to kind of hand it over to see if there are any questions, and then you all can decide if you would like to move a motion forward to vote on essentially adopting this county policy. So a little history here. The Virginia General Assembly made several important changes to the Virginia Freedom of Information Act, or as we call it, VFOIA, during its 2021 session. Those changes relate mainly to electronic meetings permissible during a declared emergency like the COVID pandemic, and remote participation, which allows some members of a public body to participate via an electronic communications means, as long as a physical quorum of the public body is assembled. So because of the nature of the pandemic, was rendered unsafe to meet in person, either for the public or for the members of the county's various boards, authorities, commissions. Both the Board of Supervisors and the General Assembly had to quickly implement new legislation and tools that would allow BACs, or those boards, authorities, and commissions, to conduct their business either fully or partially by electronic communication. The Board of Supervisors enacted a continuity in government ordinance, and the General Assembly enacted amendments to budget bills that fully authorized public bodies to meet electronically. So obviously, I think we're all aware of this. It's part of the history that we've been working through the past year and a half. So in reviewing the 2021 changes to VFOIA, it was important to note the difference between an electronic meeting, in which all members of a board and the public's access are remote, and remote participation, which is only some of the members of the board are remote, and a quorum of the board and the public are physically assembled in one location. I know this is a lot, we'll get through it here in a few minutes. The electronic meetings are authorized and continue to be authorized only if a state of emergency exists. Remote participation is authorized as long as the board has a policy, i.e., this is why we're all here, in place, a policy in place that details when a member is permitted to attend remotely. Remote participation may be used both when a state of emergency has been declared, but the board intends to meet in person, or when a state of emergency no longer exists. So the General Assembly amended Virginia Code, and I have the references if they're not clear enough in the policy, that authorize public bodies to allow a member who is unable to attend a meeting due to a family member's illness to participate in a meeting remotely through electronic communication means. Previously, remote participation was permitted only for the member's disability or a medical condition. The member must be prevented from attending the meeting because the family member's medical condition requires the member to care for them. The amendment that was moved forward also alters the calculation of the number of meetings a public body member may participate in remotely due to personal reasons. So moving forward, a member may participate in 2 meetings remotely, or 25% of the meetings that are held in a calendar year, whichever is greater. Please note that there's no limit on the number of times a member can meet remotely due to their own disability or medical condition, or of that of their family member. Nor does the statute provide any guidance as to what constitutes a personal matter. As such, boards should not attempt to define acceptable reasons. I know this is a lot. Let me just get through the next slide, and then I can open it up for questions. The policy I emailed you all last week explains all of these details, such as mandatory requirements and requests for remote participation in the corresponding sections. Essentially, if a board member needs to participate remotely in a meeting, the board member must email the Wetlands Board Chair and myself, or the staff liaison, and explain why you are unable to physically attend a meeting due to one of these 3 reasons. And they're bolded in the slide right here: a temporary or permanent disability, or other medical condition that prevents a member's physical attendance, or a family member's medical condition that requires the member of the board to provide care for such a family member, thereby preventing the member's physical attendance. Or in the first bullet, and as stated in the first bullet you see here, the second bullet explains the third option, which is the personal matter, and identifies with specificity the nature of, and requires you to identify the specificity of the nature of the personal matter. Please note that if you pick reason number 1 or 2, that will be recorded in the meeting minutes. So if we have someone who's calling in for their own physical disability, medical condition, or a family member's, that's all you need to say, is essentially, I'm calling in because of this particular reason. If you have a personal matter, though, that prevents you from participating in person, like you're traveling for work, or you're on vacation, or I don't know, your car broke down earlier that day, you could recognize that this policy states that if a member is allowed to participate remotely, or if the member is allowed to participate remotely due to a personal matter, such matter shall be cited in the minutes with specificity, as well as how many times the member has attended remotely due to a personal matter, and the remote location from which the member participated. Again, so it's clear, you'll need to state the reason why such a matter shall be cited in the minutes with specificity. So again, you do need to explain why you're not there for a personal matter, and you need to explain what that just you can say as much or as little as you want. But we do need to explain that. And I will say I'm not the legal expert on these changes in the Virginia Code, and I can try to answer any questions you may have. I can open it up, and if you are talking and you feel like you can't unmute yourself, let me know, and I'll try to unmute everybody here. So are there questions? I know this is kind of out of left field, but it's really strongly recommended that we adopt this policy.
So Catherine, before you open up to questions, I think we should make a motion to adopt the policy and that we can discuss it. Do I hear a motion from the floor to adopt the policy as recommended by the Board of Supervisors? Someone has to unmute and move it for us.
I move to adopt the policy as recommended by the Board of Supervisors.
Do we have a second?
I'll second that.
Dean seconds. Discussion. Would anyone like to discuss the matter?
Yeah, I'd like to discuss the matter.
Go ahead.
So there's reading through this, I'd be curious about what depth of specificity is required here, because a lot of this appears to be what we would call personally identifiable information, which is protected by federal law. So not sure that we are required to disclose, disability or medical conditions as a matter of public record. I don't think that is
Yeah, and I don't think you need to state what that condition is. I think you just need to say that that is the reason. Either I have a medical condition that prevents me from being in person tonight, or I have a family member that I need to take care of. I don't think you need to explain anything further than that.
So that clause then shall be cited in the minutes with specificity, right? What's that specificity?
Well, and that's where the county
Wait,
attorneys.
the specificity is only for a personal matter.
Yes.
So like if your car broke down and you can't make it, you got to say your car broke down. And I would point out with this, you don't have to participate remotely at all. It's never a requirement to do so. This only provides you the option to do so.
Right.
There are other boards that have debated adopting policies to do this in the past. I'll tell you, EQAC has discussed it several times, and the complexity of doing it, at least to EQAC, did not seem worth doing. However, the Board of Supervisors has asked us to do this, but it certainly is not a requirement that you have to participate remotely.
Right, understood. Okay, no, that clarification makes sense.
Yeah, and like I said, the statute does not provide any guidance as to what constitutes a personal matter, and it is not the role or the job of the board to try to determine what is a personal matter. And if someone says my car broke down, is that an appropriate personal matter? It's not defined in the amended Virginia Code. So therefore, the county attorney's office is not recommending boards try to dig into that.
Katie, I have a question. This is Anita. You may have mentioned it in the beginning, and sorry if I missed it, but does this policy make any clarification or have any specific discussion for remote participation for meetings versus hearings?
That's a good question. I don't recall that being discussed, but I will write that down and I will get back to you all. I may need a few days, but I will ask about that.
Okay, and just a follow-up question. This is only in reference to board members, but is there any policy either in place or being considered to allow community members to participate remotely in either meetings or hearings?
I mean, I don't think that would be covered under this just because the public, because board members and commissioners are required to be at a certain number of meetings, that they can then translate this over to the public, because I believe this Virginia Code section is just about authorizing public bodies. So I don't think it applies to the public. Now, I will say within Fairfax County, we are considering having both like virtual attendance for the public and in person, but this also, so like that is an option. I think for the Wetlands Board, you all could consider whether or not you want to have both options moving forward. Just because we have larger task forces, you know, with the public and such. And I would say that, you know, the other fine tuning of this piece that's really important to capture is the fact that if you do have remote participants, you still need to have quorum that is in person unless there's a state of emergency.
Right.
So I think that was an important piece of getting this amendment approved by the General Assembly too, and signed by the governor.
Okay, thank you. Over.
Does anyone else have questions or discussion?
I have one, I guess, as to when on the personal matter, when is that disclosed to the public? Can somebody figure out when I'm going out of town and case my house, or does this only appear in the minutes after the fact?
Yeah, it would appear, I mean, if we have virtual participation, that obviously would be disclosed on the call so that all members can be aware. And then yes, it would be recorded in the meeting minutes after the fact and posted online.
But there would not be something in advance in the agenda package
No,
as to who is or is not participating in what medium.
No, it doesn't. That doesn't need to be communicated at that time. No, not ahead of the meeting.
And I would note that the minutes tend to come out months after the meeting.
I'm trying not to get them out months after the couple of weeks,
Yeah,
maybe.
but
yes,
you have to do the minutes and then we have to vote to approve them. So they don't really get published until after the board approves the minutes. Any other discussion? All right, I'm going to call the question. All those in favor signify by saying aye. The chair votes aye.
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 Aye. Aye.
Aye.
Are there any nays? Are there any abstentions? The motion passes.
all right. Thank you, everyone. We're going to move on to just a quick update I had for everyone on the proposed comprehensive plan amendment and the zoning ordinance revision that we've been talking about related to some previous Senate bills that were passed a few years, not just a few years ago, and then the most recent Senate Bill 776. Just to reiterate, and it's more for me to explain to you all where we are with this, but again, this is the whole piece of integrating living shoreline strategies into not only the comprehensive plan, but for the county, but also to bring our wetlands zoning ordinance up to the latest version and language that aligns with the state code. So I showed you this slide last time we met in March. I just wanted to give you an update that the area in the blue box or the green box is what we're proposing to tweak, and we're going to reference how we want how when talking about avoidable impacts to the wetland areas and to the Chesapeake Bay as like, again, a comprehensive planning process. We're gonna keep the guidance consistent with VIMS in the Virginia code that supports the application of living shoreline approaches as preferred approaches for stabilizing eroding shorelines. Again, this is just kind of beefing it up. If you all know and understand and can appreciate the comprehensive plan, it's a very high level planning document. So it's not really meant to be super specific, but we are going to reference back to the guidance that VIMS has been charged with via the Code of Virginia to support the living shoreline approaches. So I'll have some new proposed language there. And then this is an appendix to the comprehensive plan that has not been updated in quite a while, and it talks about it kind of references a bunch of different areas and data points, and really what we're going to do is clean this up and remove those title definitions of erosion rates that are indented below. And I have coordinated with VIMS and VMRC on some of the proposed language for this section. And Emily Haynes from VIMS was able to give me some feedback from her team. And we're going to reference things like the comprehensive coastal resource management portal that VIMS has created. So there's going to be some edits there. And then
Catherine, before you leave that one,
yeah.
Are we going to keep the reference to the Hampton Roads guidance? Or?
No, I don't think so. I think that's going to come out too. That whole paragraph needs to be updated.
Right. So just for everybody's edification, not everybody was here when this started. The original language of this could have been interpreted to interfere with some of the Wetlands Board's authority. And I want to point out, with Catherine taking over this and working directly with VIMS and VMRC, I think those issues have been addressed. I'm sorry, I interrupted. Continue, please.
No, it's fine. It's fine. And then at the very end of our entire comprehensive plan at the county, there's a list of a glossary of definitions. So we're going to add the state's definition for a living shoreline here, since we're going to be referencing it in the previous pages that I showed for the comprehensive plan. Right now, there's no definition. So we think that'll be a good addition. And then, so that takes care of the comprehensive plan. It's not a huge amount of edits, because really tidal shorelines and tidal wetlands are not specifically called out in so much detail, just because there is a zoning ordinance and we have a wetlands board and things like that. But for the zoning ordinance, again, the most important thing we've been asked by VMRC is to make sure that our wetlands ordinance mimics, matches, is aligned with the latest updates to the state's zoning ordinance for local wetlands boards to use. And that was updated through the Senate Bill 776, I believe, where now it talks about how they added language where living shoreline approaches should be used unless best available science. This is all quoted, obviously. This is stuff that was written into the bill, that living shoreline approaches to shoreline management should be used unless best available science shows that such approaches are not suitable. Again, that was a new piece put into the state code that needs to be discussed here. And then there's also a section that talks about making sure that the destruction of wetlands is prevented, and that wetlands, the tidal wetlands need to be preserved, and then ensuring the protection of shorelines and sensitive coastal habitats from sea level rise and coastal hazards. So again, like very specific language on this side of on this zoning ordinance, this state code piece that we're going to be integrating. And then I just wanted to share with you where I'm headed. So there is a comprehensive plan amendment that was passed by the Board of Supervisors 2013, so a long time ago, to update the comprehensive plan with these living shorelines. And for, I think, a couple different reasons, that comprehensive plan amendment was never really completely finalized. So I am driving that boat to get it finalized by the end of this calendar year. So my process is that right now I'm routing all of the proposed edits to various county agencies. Clyde and Anita have had a chance to take just a cursory look at it. And then I am going to be giving a presentation next Wednesday evening to the county's Environmental Quality Advisory Council, or EQAC, about this whole topic. And I'm also going to be providing a presentation to the Planning Commission's Environmental Committee, likely on Thursday, July 29th, ahead of that public hearing in September. So
Catherine, I'm just trying to understand, and I know you're trying to kind of update. It looks like the board, you know, our edicts to address the living shoreline. I'm a little concerned with just saying we want living shorelines when there are so many conditions that do not meet living shoreline requirements in this area. I'm a little concerned that we need to really be able to possibly draw a line or provide examples or something. And I know, you know, you're going to be referring back, but I just want to throw in some caution there. We do have numerous areas where living shorelines are not appropriate.
right, and I think that's where, and obviously I don't want to speak for the team in Richmond who would have put together the Senate Bill 776 language that we all saw and reviewed. But I think that's where that clause of unless best available science essentially proves otherwise, you know, living shoreline should be used, should be I'm butchering the actual definition.
So if I could add a comment to Kim for a second here. The two things that are in front of us here, the comp plan is just a description of what's happening. We've been tracking that. If you have some objection to the way that language is being produced, definitely want to communicate it to Catherine. The Chapter 116 modifications are required by the new state law. I don't think we have much flexibility in that. The flexibility could come in how it's written. We could just do it by reference, or we could repeat language, but effectively the language of the regulation needs to go into 116. Addressing your comment, you know, how do we deal with where living shorelines are actually required? I think that comes out of the interpretation of the VMRC guidance, which is next on the agenda. But I don't think there's much flexibility in what goes into Chapter 116. And Anita and I have been working with Catherine on this. You're certainly welcome to comment, but I've come to the conclusion that we're pretty much at where we're going to be on 116. Anita, do you want to add something to that?
No, that sounds about right to me. I'd be interested to learn more about Kim's concern. My experience with the Wetlands Board and the applicants that we work with and the community that we live in, having too many living shorelines has not been a problem. And I think most people are well aware that there are required conditions, restricted conditions for it, but it's been the policy and the legislation to promote it as the alternative of choice where possible and appropriate. So I think those things are manageable at this point. Over.
Yeah, I'd like to get copies of it and just be able to see. I mean, I understand the policy, and I'm certainly all for it where it's appropriate, but we do have many areas that, and the things that come to us, many of them are not appropriate. So it would be, I think we would be remiss in not addressing or somehow mentioning, where appropriate, where best available. Yeah, and I'm sure it's probably in there. I would just like to take a look at that. If
Yeah,
I can copy, that'd be great.
I can send around, VMRC put together, or they updated their guidance document that accompanies changes like this at the state level, and I'd be happy to send that around to everyone. Let me just make a note. That was just approved by their commissioners, I think in last month. And I was also going to point out that the county has a living shoreline policy also that I think a couple of us have realized may need to be dusted off and maybe just have another look at it, to at least at the very least, that it agrees with what the zoning ordinance and comprehensive plan are going to be saying at the county level. And then, that might be an area where we can add or modify. Also, we have the supplemental form that we ask all permit applicants to fill out for us, or for the county and for the Wetlands Board to help in reviewing the application. So there could be ways that we could consider tweaking that to maybe help document what data an applicant is looking at, or help them record, the pros and cons of a living shoreline concept. So I'll just throw those ideas out,
But before us here, chapter 116, you can absolutely comment on it if you wish. I do think that what Catherine has put together pretty much follows what's required under the state regulations. Catherine, should we move on to the checklist? Is that our next
sure.
item?
Yeah, I actually did not put that at the right spot, so let me.
Let's run through the checklist just quickly before we do this, just so we get to it. If I'm skipping the agenda, let me do that.
Okay, so this was also an item that I emailed out to everyone. I believe that was on July 2nd.
So this is a list that I put together for my own edification. I would ask that you don't cite it because it really hasn't been approved in any manner, way, shape, or form. But I went through the new VIMS guidance and listed what I saw as all of the requirements. And I would recommend to the board members that you become intimately familiar with the VMRC guidance, because that is what we're now going to have to apply in future permit actions. On this list here, the first couple of things are existing, but the rest is all new. And I don't really want to go through all of this evening, but it would be helpful, I think, for all of you to read this and consider how you are going to react in a board meeting to one of these questions. because we don't necessarily have guidance on exactly what to do with each one of these items. And in particular, I would point out to you the requirement to now provide scale drawings. In the past, we haven't had those kinds of requirements for wetlands permits. And the requirements on these scale drawings are extensive. You know, the square footage of existing wetlands, the grade elevations, the slope. Most importantly, the mean low water, mean high water, 20-year NOAA water level. In the past, we did not have to have a specific criterion for examining climate change. We now do. And the applicant must come to us with what they think their project life is going to be and what they anticipate the actual, and what NOAA says the water level will be on the drawings. And then it gives this long list of things that we have to consider: fetch, bank composition, near shore stability, boat wicks. I think, Kim, those are things that you were thinking about might change whether or not we would require a living shoreline or not. But I'm going to point out that we do not have numeric criteria for these things. It will still be up to us to make a decision on them. But we're going to have the information in a way that we've not had before. And the burden on the applicants is substantially higher than it was. So with that, I'll stop and just ask that, you know, people spend some time and become familiar with these things. Anyone have any, if you haven't had the opportunity to study these, I would just encourage it. But does anybody have any short questions they'd like to cover? Hearing none, Catherine, why don't you go ahead and return to your presentation on the hearings we're seeing coming up?
Okay. Sorry. Okay. So I had also emailed you all, let's see here. I think that was when I emailed out the meeting agenda for this. So maybe that was last Friday. Letting you all know that we had kind of an issue come up, and this portion of our presentation, or this portion of my presentation for you all, is for informational purposes. More to come on this. But just to give a little context and history, on the evening of Tuesday, June 15th, myself, BMRC, and the county's Land Development Services, or as we call them, LDS, received a complaint about ongoing work being done at this property. BMRC, VIMS, myself, and board members Clyde and Deanna were already scheduled to visit 3 other properties 2 days later on Thursday, June 17th. So we added this location to our list of site visits. BMRC and the county determined that no permits were submitted for any of this work. And the image you see here is actually from county oblique imagery of the property at the shoreline from 2020. So sometime about a year or so ago. The slide forward. Okay, so because a complaint was also sent to the county's Land Development Services Department, a county code compliance inspector visited the property the day before myself, Clyde, Deanna, BMRC, Vince did. And this inspector collected these 3 photos from the property owner that the property owner said was from a flooding event in early 2021. I don't have any additional details at this time about the dates in which these photos were taken or what the conditions were. All right, the county inspector heard from the property owner that they believe this project was warranted emergency action because of a failed bulkhead. Hopefully those pictures made some sense. So the next 5 photos I'm going to show now were taken from our county code compliance officer, the same one who collected the previous 3 images. Again, he was able to go out to the site the day before myself, Clyde, Deanna, Mark Eversole were. So the first one shows the overall scope of the project. When our county code inspector was there, work was ongoing. There were folks on the site working on the project. This next image shows like new pilings that you can see. The next one shows the depth of the water behind the new bulkhead. The next one shows the slope of the property, if that gives you some context. And then this is just another image of the ongoing work. And again, these photos were taken on June 16th. So, and just to provide a little bit more context, the property owner was away on vacation the day that myself, Clyde, and Deanna were hoping to get onto the property to take a look. However, because the property owner was not there, we were not granted access. So we observed the site from across Massey Creek from the neighborhood marina. And these are 2 photos that I took from the marina. So after we all saw this, after some coordination, I issued a sworn complaint on the following Monday, June 21st, and then Clyde, the board's chairman, issued a stop work order that same day for the impacts titled Wetlands without a permit. That correspondence was sent to the property owner and the contractor. That's a contractor down in Westmoreland County on June 21st and posted to the front door of the county's residence. Just so you all know, the county Department of Land Development Services also posted a notice of violation for work being done without a permit in the RPA. Okay, so all that being said, where are we going from here? So a follow-up site visit occurred 2 days ago on July 6th with VMRC. So Mark Eversole was there and Clyde went. I wasn't able to go because of a prior work commitment. But so maybe in another minute or so, we can give Clyde a chance to share any information he saw on the property on Tuesday. But so after this board's meeting tonight, the board chair will finalize a notice to comply letter, which will be sent to the property owner and their contractor agent. And we'll ask the property owner to do the following: appear before the Wetlands Board at a future show cause meeting, which we're hoping to schedule for early August. Again, that's why I was trying to collect availability from you all, where the board will hear from the property owner and make a decision on if the completed work will need to be removed or have the property owner submit all necessary permit applications. We will discuss the date of this upcoming show clause hearing meeting in a few minutes, which is, a later task on our agenda. I would also like to note that Mark took photos of some of the vegetation on the site when he was there on Tuesday, and he sent those images to Emily at Vince to ask her to consult on the species to determine if the site would be considered as vegetated wetlands or non-vegetated wetlands. So that's what I know up until this point. If anyone has questions, or Clyde, if you have anything that you want to say based on how things are at this point.
No, I would note that there is an aspect of the regulations that allows for emergency construction, that the Wetlands Board chair can issue an emergency permit. That was not done in this case. I would also note that the photos that we've shown would appear to show a bulkhead that was missing in 2020, if the accuracy of the date is correct. It would appear from the inspections that the wetlands are jurisdictional. In other words, they are under our jurisdiction. It remains for the homeowner to make a case for whether or not an emergency was required and whether or not there was or was not jurisdictional land in place. And we'll be looking for an application to do that. I would point out that the picture you currently looked at on the left, you're really seeing the adjacent property, and they already have a emergent living shoreline there, which appears to have extended onto the applicant's, the violator's property here from the previous
See if I
pictures.
can- Yeah, you can even see that somewhat from this oblique
Yeah,
image.
If you look at this picture, you can see that the area just to the right in the picture of the boathouse, if this is truly a 2020 picture, the bulkhead is missing. There isn't something to be repaired here, it's gone. It's unclear if the rest of the bulkhead failed in the later 2021 event that was referred to.
Yes.
So
I have
the
some
important point here
questions.
is we're going to have to issue a notice to comply, but it's extremely important that we have a quorum for the date of that notice to comply hearing. So Catherine, you're proposing this on what date?
On August 11th seemed to work best for everyone, but if things have changed and that does not work for the majority, then we will move it. But I heard Anita say she maybe had a question or two.
So I have to say that I'm kind of a problem here. I have an EQUAC meeting that night. Were there any other
Right.
dates that look good?
Okay.
I'm sorry.
Okay. Let me see if I can pull those emails real quick to see what you all said. Maybe if there are questions, you can ask those while I look for everybody's responses.
Did he provide a date of when that flooding event occurred?
No.
We don't know. We don't have any dates. What you see is pretty much what we know. We would hope that the applicant in the show cause hearing would come forward and identify when the photos were taken. Because, you know, from the looks of it, you have a situation where a living shoreline is probably something that could very potentially be required under the new guidance.
And so well, one of them looks like a flooding event, and it looks like the same elevation as the marsh across the creek.
Oh.
So I'm not sure that the flooding event was precipitated by anything, but the boathouse, is he saying because his boathouse fell in, why did he dig out the boat area?
We don't have an answer to any
No
of your
idea.
questions.
Okay.
All
All right. Okay.
All we have is the observations and pretty much what you see. We really should allow the applicant to come in and show cause here before we make any decisions or projections. I am
agree.
concerned about the missing bulkhead on the right picture there.
Yeah.
So I'm sorry to do this to you. Any chance we could move the hearing to the 11th? Excuse me, to the 10th? Let me just ask that question. Could everyone here make an evening meeting on Tuesday, August 10th?
Yeah, that shouldn't be a problem.
I can do it.
Yes.
Catherine,
Yes.
do you remember what the poll of the other members were? Could they do it the 10th?
Sorry, I'm still trying to check.
I'm sorry, this is my fault, folks. I
Maybe-
told Catherine I could do that date, and
Clyde, maybe we could do another, maybe Katie could do another doodle poll or.
We
sit-
really can't. We can't because we have to give the applicant 30 days notice.
No, I understand that, but if we send out something electronically tomorrow for all of us to confirm what the choice of the dates are, that might be helpful. I mean, at the moment I can do the 10th, but just to get it confirmed, that might be helpful.
I think, yeah, I mean, this is kind of up to you all and like how you want to organize this and how you want to schedule it. I think Doug Klein had said maybe that he was not available on the 10th, but the 11th was better. So I think that's why I picked that.
Doug, can you do the 10th?
I can, there's a conflict on the 10th, but I can do it.
So what I'd like to propose here is that we give Catherine until Monday, which is, what is Monday? What's the date?
Well, there we're getting a little close because if I don't mail this letter, Clyde, until the 12th, then we can't have a meeting until after August 12th because we've got to give the person
Yep.
30 days.
Well, look, we've got a quorum here. I hesitate to open this up to go later into August. And I'm also a little concerned, Anita, that we've done the stop work order. And once we do that stop work order, we really have to proceed with this hearing schedule. So
Okay.
I'm gonna make a decision here to say we're gonna go with the 10th. And Catherine, we can talk about the signature either right after this or tomorrow.
Okay.
So can I ask a clarifying question about the situation, not the dates?
Sure.
Katie,
Mhm.
a stop work order was issued and you're confirming that work did stop, is that right?
I believe so. I was not at the site on Tuesday. These
Okay.
pictures obviously were taken on the 16th, but the stop work order wasn't received probably by the property owner and the contractor agent probably until like the following.
Mhm.
So we're talking like maybe 5 calendar days. Sorry, hold on. So it may have been like up to potentially a week after these photos were taken, just because we had to generate all of that paperwork. I had to get it
Right.
out to the post office and stuff. So there could have been more work done based on after these photos were taken, but the project I don't believe is finished. But Clyde, you can correct me if I'm wrong.
Anita, my impression is that work has stopped. We met with the owner's agent when I was out there last, so she's totally aware that she has to stop work.
Mhm. Okay, and when they come to the show cause meeting, the choices then before the board are to instruct them to remove the work to undo what they have done this far, or submit retroactive permit applications.
Yes, I think we have 3 options. Is that right, Catherine?
It's just 2 options. Let me see if I can pull that up and I will read it for you all word for word if that helps. Second.
So while Catherine's looking for that, I want to thank Randy Owen for being here with us tonight. Randy is Randy, what is your position at the moment with VMRC?
Well, I made chief in late May, chief of the division.
Congratulations.
I was the deputy chief. Thank you. I was the deputy chief for 2 years.
So for everybody's edification, Randy did have a job similar to Mark Eversol's for years. He's worked with many wetlands boards, and he's been a big part of writing the VMRC guidance. So, Randy, if you want to jump in and tell us what our possibilities are here, I mean, we could tell them to submit a new. Go ahead, I'll listen.
Yeah, the show cause hearing is a very common practice that I've seen from everywhere from Virginia Beach up as far north as Fairfax, of course. And, you have during that hearing, I would think you need to decide whether you do or don't have a violation. That would be your first order of business. And you have the option of either that's the hearing where you can give them 30 days notice of a restoration hearing. That's the 30-day notice requirement. You basically just bringing them in because they're in violation of it appears they're in violation of the law. But, once you get them in front of you, if you rule that there is a violation, you can either, through your notice to comply and action, you can direct them to either submit an after-the-fact application if you think you want to entertain possible approval of what they've done, or you can essentially direct them to remove everything and restore the site. But that's where you have to bring them back after a 30-day notice of a restoration hearing.
So what I meant by the 30 days is we have to give them 30 days to show up for the show cause.
No, it's actually for a restoration hearing. The show cause is just unless you intend to order restoration that night, then you would have had to given them 30 days. But if your show cause hearing is just to determine, every county does it a little differently, but at least in Virginia Beach, where I worked for years, working with that board, they would bring in a show cause hearing, and all they would decide that day is whether or not a violation had occurred and whether or not they were going to entertain an after-the-fact application. And if not, then they would give them notice at that hearing that they had 30 days to appear again for a restoration hearing, where they were to be, to appear with a restoration plan in hand. And then, of course, they didn't follow that, then they would proceed to court for, civil action.
Okay.
But I'm happy to, I think Catherine may be ready to speak, and she has, something she'd like to share.
No, I don't at this point. I mean,
Yeah.
I can read the two options as we had them drafted in the notice to comply letter. And this was based off of, I think, the last time this happened at the county, which was maybe like 2006. But we say a hearing date is scheduled for August, whatever date we're going to decide, let's say the 10th, for you to appear before the Wetlands Board. Purpose of the hearing will be to determine what action will be taken, including but not limited to the Wetlands Board may order that the affected site be restored to pre-development conditions if the board finds that restoration is necessary to recover lost resources or to prevent further damage to resources. Or, this is the second option, requirement to submit a completed joint permit application to the Wetlands Board and VMRC in accordance with specific guidelines for such submissions.
So I would agree with the chairman then, since it sounds like the way the notice to comply is worded, that if there's potential that you would order restoration, you would need to give them the 30 days. That's correct.
Yeah.
Just, the boards drag it out a little longer, and I don't particularly like that. I kind of like the way y'all got it worded, personally.
So, it will be up to the board at that hearing to decide. Really, there are three options. We could say you're not in violation. We could order to restore. We could tell them you got to submit a permit. And
It's Kim. Is there a third option? I'm just thinking, because we've been talking about living shorelines, would that be considered a restoration? Like, how far? I guess
if we ask them to submit a permit, we would ask them to address the new VMRC guidance, all of it.
And the county guidance.
The county regulation.
Yeah,
Yeah,
okay.
the 116, but the 116 is not adopted yet.
Right.
So I don't think I would refer them to that at this point. I would simply refer them to the state code.
But isn't the
At this point.
policy also adopted though for living shorelines?
It is.
Yeah.
However,
Okay.
I think the VMRC guidelines are more stringent.
Okay.
And those VMRC guidance applies to us. So at this point in time, us as the Wetlands Board, at this point in time, I think the VMRC guidance is the most rigorous. I would certainly tell them to read the new regulation, all of the sections, and I would tell them to interpret the guidance.
Can,
So there aren't
okay.
many of these applications that have been made. I have asked Mark Eversole to, if he has an application under the new rules that he considers to fully meet the new guidance, to provide it to us so we have some idea of what a good application looks like. And we could decide at the hearing whether or not we want to provide that to the applicant as guidance, or whether we just want to tell them you've got to follow the guidance.
So how does that fit in? And I'm just asking this question because I really don't know. And Randy, maybe you can join in here. So I'm looking at Google Earth and going back in time, and it looks like they did have a bulkhead in 2005. It deteriorated in 2012. Some of it was missing at that time. So is there a supersedence with living shorelines? Is there a maintenance? I'm just throwing this out there. I just trying to understand when we ask for a restoration, like what does that entail if they really did have a bulkhead? And was it previously permitted? Do we know?
The house is quite old. We don't know if it was previously permitted. That would be on the applicant to establish. I think that you have regulated wetlands jurisdiction extant based on the pictures. I
would
don't
agree.
think we could. I don't want to prejudge what the board would do here. However, you're going to be asked, can this bulkhead be maintained? Can a maintenance operation be maintained on a bulkhead that's gone?
Right, with the living shorelines, with the changes that have been made, has that come up yet? I was just asking Randy for if that's
Even if we didn't have the changes, I think we would have to have a full new application, and it would have been our policy to favor a living shoreline, even before this.
true. Yeah.
Can you go back to that picture with the missing bulkhead?
Sure. 1 second.
This is Anita. While we're doing that, if I may
Well,
ask a
back
question.
up. Stop there for a second. All right, this is perfect. Now, this is low tide. At high tide, the water is going to be up along that slope. So, I think if we asked staff, or if we asked BMRC, or if we asked VIMS, they would say that's jurisdictional wetlands. And you would be asked, can you maintain the bulkhead? So I'm not telling you what the answer to that is. And we may have to hear from the applicant on what they have to say about it.
Yeah, okay. I was just asking, yeah, for restoration purposes. Like if we're gonna say, I don't know that we can make a decision at the next meeting. I think we would have to have another one regarding restoration.
Absolutely. At the next
Okay.
meeting, we have those three options. We can say what you did is okay, goodbye. We can say restore, or we can say make a full application.
Right, and if we say restore and 30 days later they come back with their restoration plan, what criteria are we going to use to judge the validity of that restoration plan, and restoration to what baseline? That's what I'm still not clear on.
I think that we would have to apply the new VMRC guidance. I know that's a horribly vague statement to make, but that's what we've got. Randy, do you want to jump in? I'm sorry.
I want to make sure that I don't, just like you don't want to prejudge something, with us sitting as an appellate authority, I got to make sure that my comments are in no way, shape, or form prejudicing the board. I would agree in the photograph on the right, as you say, there's no question that that's a jurisdictional wetland area. So no question there. And of course, kind of getting back to Kim's comment first, when I think of restoration, I typically think of wetlands that are not hardened, and you go out and you fill wetlands and you make them restore the wetlands. When you have a previously bulkheaded site, and I'm guessing I would have to ask, maybe some portion of that bulkhead is standing from what I think I know. Is that correct?
Yes. Well,
yes.
We don't know.
Okay.
I got to be careful. I don't know.
Okay. So, my thought would be is if they had come in the door requesting authorization, to repair the wall, I think that would be, where y'all would say, well, based on the current guidance and the current law, either is or isn't a suitable site for a living shoreline based on the best available science, and go from there. What you've got obviously is an unauthorized wall, and whether it can stay or not, to me, would be a function of how you would have looked at it had they come in before the fact, and just pretend the wall's not there. And I'm afraid to go much further because I fear that I would be prejudicing the board, and I don't want to do that. I'll try to answer questions if you have a specific question.
No, I appreciate that. That's helpful. But I don't think, like, Clyde, I think we're going to need more than, one. This will definitely be a couple meetings, I believe.
Well, yes. I mean, this next meeting is only to establish one of those three options. And to kind of give the applicant a chance to come in and make their case. And again, we have to choose one of those three. So, folks, I understand that this is a little uncomfortable. We have a new law. We have a new regulation. We have new guidance. And this is the first place we're really going to have to apply that.
Yeah, I'd be curious to hear what the home or the property owner has to say about it.
Well, that's why we have the hearings.
Right.
So, Catherine,
Mm-hmm.
We're going to move forward with this. I'm going to sign the show cause hearing for the 11th.
Or for the 10th.
We'll go from there.
We're going to do it on the 10th, though?
Yes, I'm sorry, the 10th.
Okay.
Yeah, Catherine and I will take care of the show cause letter, and we'll anticipate a hearing on the 7th. Excuse me, I keep doing 7 o'clock on the 10th of August.
Yes. Okay. Everybody mark that down in your calendars for me, please. And just to follow up on that, because especially because of the nature of this meeting, plus the fact that, the governor's state of emergency has run out, this will need to be an in-person meeting. If you cannot be there in person and you have one of the 3 reasons to participate remotely, please, again, because of the sensitivity of this meeting, please let me know by July 26th so that I can make sure that I arrange for your virtual participation. But we do need to have quorum in person, very least. So, and then
All right.
I,
Catherine, do we have any public people present?
we have one caller as just a guest, but I'm not sure if that's, oh, that person
The guest
just
has
called.
left the meeting.
So I don't see any others. I will unmute everyone though. See if I can, maybe I don't have the ability to do that today. Let's see. Yeah, if, or anyone can raise their hand if they want to.
Does anyone have any comments? I would entertain a motion to close the meeting.
I'll second that.
I need a first.
Oh, sorry.
Do we have a second?
Second.
All those in favor?
Aye.
Aye.
Okay.
Any opposed? All right. Thank you very much. And Mr. Owen, thank you so much for attending with us. And I know you're a very busy man, and we really appreciate your help and assistance.
I want to say very quickly that all of the wetland boards are critical to the program, and you know, we don't always get it the way y'all want it and vice versa, but we sincerely appreciate the hard work y'all put in, and we will continue. The guidelines are definitely going to be work in progress for all of us, and that's why we want to get Emily up there to the site with Mark. So we will do our very best to help you on a case-by-case basis.
Thank you very much.
Thanks,
you all.
Randy.
Thank you all.
Good night, everyone.
Congratulations, Randy. Have a good drive back.
Thank you, ma'am.
Better like that 64, huh?
Thanks, everyone.
All right, thanks.
Catherine, I'm going to call you.
Okay.
Are you back?